Hello, this is Matt on the Moon Lambeau channel. If the SEC versus Ripple case isn't a slam dunk for Ripple at this point, I don't know what in the ever-loving hell is going to make it a slam dunk for Ripple at this point. Like, the SEC, which, mind you, I'm sure most of you are aware, claimed that former SEC Director William Hinman's opinions and his speech about Ethereum and how it's not a security, just his opinion, right? Well, not so much. Now we have the SEC telling a market participant to use those opinions from that speech as guidance. The SEC said that. How is it? This is a bombshell, right? This is the SEC admitting that the Hinman speech, it's not just his own thoughts, it's the SEC's. I kid you not. I don't know how this could not be a slam dunk for Ripple. It's just mounting evidence like piece after piece, day after day. It's unbelievable how sloppy the SEC is. And so it's like, before they brought this case, if they really thought they were going to get away with this, it's like, did they not know what they had been doing for like the last, almost decade, and what they had been saying and advising? It's like, did they check the skeletons in their own closet? I don't think so. Or if they did, they're so damn cocky that they're just like, oh, it doesn't matter. We can do whatever we want. We're the SEC. That's what it sounds like. And so I'm going to share with you all of the specifics, but before going further, I do want to be clear that I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who makes YouTube videos all up on the internet, but just as a hobby, just for fun. XRP community member and attorney James K. Filan shared this most recent legal filing. I'm going to call it today. Technically, it's yesterday, but I'm still up. It is currently 1:38 a.m. now on Saturday. What is it, the 25th? So I haven't gone to sleep yet. It counts as today, which is so it was September 24th. This legal filing came out here, but I'm going to run through it. But before I do run through it, I want to share with you Jeremy Hogan. Attorney Jeremy Hogan's initial response to this. He, of course, is the attorney within the XRP community that runs the very popular YouTube channel Legal Briefs. And in response to what I'm going to share with you in just a moment, here is what Attorney Jeremy Hogan said. And mind you, he's been busy with his own case because he is an attorney, so he has like an actual job, right? And so he hasn't been as active over the last week or so, making videos or commenting on Twitter or anything like that. So here's what his tweet said, though. Just getting back into this case, and WTF, he wrote that, yes. And then in parentheses, he wrote legal term. So that certainly caught my attention. And then he said, the SEC sent an email to a third party telling them to analyze a digital asset using the factors in the Hinman speech. Which speech was just his personal opinion? I understand now. It's the SEC that needs clarity. And he wrote that last part in all caps and for good reason here. And so, mind you, we don't know who the SEC was advising. It was some sort of market participant. I think it's reasonable to speculate that it's some sort of firm that had an interest in a particular cryptocurrency. Maybe it's something they launched. It could have been an ICO. Even if it wasn't an ICO, they're still trying to figure out, okay, what do we do going forward? So they're asking the SEC for help. And the SEC pointed them to the factors contained within the Bill Hinman speech, which took place on June 14th, 2018. And that's when he said that Ethereum is not a security, just his personal opinion, though. And then he went on to cite the reasons why. And so then there was also this. Somebody named Anna saw what Jeremy Hogan wrote there and said, WTF is highly appropriate, to which Jeremy Hogan responded with something comical, so I thought I'd just share it for the fun of it. He wrote, it's the first phrase that came to mind, so I went with it. That usually works for me well in my law practice and poorly in my marriage. I got a kick out of it anyway. And so then I retweeted what Jeremy Hogan shared and wrote the following. Please take a look at this Charles Gasparino. Charles Gasparino is a journalist at the Fox Business Network. Many of you may be aware to this point. He's been on fire uncovering all of the dirt from the SEC and all of the conflicts of interest, the unequal distribution of justice, the selective enforcement, litigating to bring clarity to the markets, all that stuff. Charles Gasparino has been just absolutely on fire, and so I tagged him there because I want him to see this. I'm sure others are probably trying to get his attention with this one too. So I wrote, please take a look at this, and I tagged Charles Gasparino. There's proof the SEC advised a third party use Hinman's Ethereum-free pass speech from June 2018 as market guidance. Incredible, as the SEC claims the Hinman speech was only Hinman's personal opinion, not official SEC policy. Interestingly, since the SEC wants to use the Hinman speech for market guidance, happy to comply. If you read what Hinman said in his speech, you'll find that XRP meets the criteria of a non-security better than Ethereum does. There was no XRP ICO. And so that's what I shared in 2 tweets there. And so shout out to James Filan for sharing this. He's awesome getting these documents out so that the XRP community can see what's going on here. And so here you can see this is Ripple's legal team, September 24th, filed the following. And it's very short, so I'm just going to run through this whole thing. It's super short. Dear Judge Netburn, we write on behalf of defendants Bradley Garlinghouse, Christian Larson, and Ripple Labs in connection with the court's in-camera review of documents identified on Appendix A to defendant's motion filed on August 10th, 2021. And let me pause there just to note, in-camera, just anytime you hear that, because I'm going to read it as I go through the article. When you, or no, it's not an article, the legal filing, but when you hear in-camera, just replace it with in-person. So when they're requesting an in-camera review, it just means basically they're requesting that the judge herself personally review this information. That's all that this is. And the reason that the judge perhaps would do something like this is, at least in the past, because we've run into this before, is because there have been instances in the past where the SEC is claiming that there's a privilege surrounding particular documents that just shouldn't get out into the wild. Nobody else should see them, including Ripple, actually, for some of that stuff. Although these documents they obviously did see. You'll know that as I go through this. But anyway, as a result, for the documents that the SEC didn't want to get out and Ripple couldn't have, but they're seemingly relevant to the case based on the minimal information Ripple had about that, their legal team was like, hey, we're requesting an in-camera review, which just meant that they're requesting that the judge in person review the documents and make a personal determination as to the relevance of the case and whether or not that should be admitted for evidence during discovery, this and that. And in the most recent instance where that happened, the judge was like, yep, I'm going to review all of these documents, which is good. That was just another win for Ripple. But anyway, let me continue with this now. The documents identified on Appendix A represent a sample of entries from the SEC's privilege logs submitted as of the date of that filing that, based on the descriptions provided by the SEC, appear to be most relevant to the claims and defenses in this case. The court held oral arguments on this motion on August 31st, 2021, and ordered the SEC to provide the court with the documents listed in Appendix A for in-camera inspection. Now, 2 days after the hearing and the court's order, on September 2nd, 2021, the SEC provided defendants with an 8th privilege log with 19 new entries. We respectfully request that the court add 3 of those new entries to the body of documents Your Honor will review in camera. Now, these descriptions, this gets me more interesting. Check this out. The descriptions of 3 of these documents from the belatedly produced privilege log suggest they may be highly relevant to this case. 2 relate to meetings the SEC had with law firms to discuss the unprecedented confusion in the market regarding the SEC's view on the status of digital assets under the federal securities laws. And this is listen to this one. The third is an email chain concerning discussions with a third party whom defendants understand received guidance from the SEC to analyze its digital asset under the framework set forth in Director William Hinman's June 14th, 2018 speech. What in the ever-loving hell? Folks, what in the ever-loving hell? This is what I was saying. I've been saying it for the longest damn time, and I know I'm probably preaching. I am preaching to the choir here at this point. Fine, I got it. But they trotted Bill Hinman out there, And they just as a legal disclaimer, because they want to be able to argue whatever the hell they want at any given moment. They don't want to be, they don't want to commit to anything. Basically, that's it. It's like, don't date the SEC because they won't commit to you in a relationship. Just like, don't, if you're looking for something serious, like, don't date the SEC. They won't commit to a damn thing. And so they just trotted Billy Hinman out there saying all these things, but it was presented in such a way, despite the small disclaimer, it was presented in a way that this is the official decree of the SEC. That's the way the media took it. The SEC never corrected the media, and it was very clear that that's how everyone interpreted it, as official decree from the SEC. I've shared so many headlines in the media as a result of this, and they didn't try and fix any of that. If it were confusion, then they would need to do that. Otherwise, they're completely inept. And I wouldn't say they're completely inept. I'd say that it went exactly how they were expecting. And this isn't just speculation. We have had former SEC Commissioner Robert Jackson publicly state that this was the intent. I've shared the video. I've transcribed the videos and shared them on this channel. And he has publicly stated on more than one occasion that the intent was for the Bill Hinman speech to be taken as market guidance. That's absolutely from the SEC. Absolutely, it is. So that's not even really speculation at this point. Like, when you're talking about Robert Jackson, one of 5 commissioners in the SEC, at the top of the hierarchy of the SEC, yeah, this isn't speculation here anymore, folks. This is the SEC absolutely at this point lying about what the purpose of all this was, and so. Because they were so sloppy about this, and they didn't assume, I guess, that it would come back to bite them on the rear side. Now that we turn out that they got so ahead of themselves, out over their skis, as they say, that at some point here, they actually suggested us to some firm, some crypto firm that they were advising, that they use William Hinman's Ethereum free pass speech as guidance. That is stunning to me. Absolutely stunning here. Anyway, and so then the legal filing from Ripple's attorneys continues here. Had this privilege log been provided before defendants filed its motion on August 10th, 2021, defendants would have included all 3 documents in Appendix A. Indeed, if the SEC had provided this privilege log any time in advance of the August 31st hearing, defendants would have asked the court to include these 3 documents in its in-camera inspection. Instead, defendants had to ask the SEC voluntarily to include the documents in its September 14th submission to the court. The SEC filed its brief without responding to this request. So let me pause here just to state, the SEC, they did this for a reason, don't you think? Or were they just so busy they just couldn't get to it, right? No, I don't think that at all. I mean, there's no way to know for sure what the hell's going on here, but if anything, wouldn't it seem more likely that they didn't want this information to get out, or it was a delay tactic, and then they would hope that as a result of this not being included in that initial batch, that there wouldn't be an in-camera review by the judge? Maybe that has something to do with it, even if highly unlikely, because I don't see how. We'll see what the judge says, but based on what we know now, why would the judge not want to personally review this information? This is really big and highly relevant. Anyway, then the Ripple's attorneys write the following. The next day, the SEC indicated that it would not submit these documents for the court's in-camera review absent a specific directive from the court. Well, what do you know? So they didn't want it to be reviewed. They kept these separate from the rest of the documents. They don't want the judge to be personally reviewing this information. So it's an extra little hurdle to get it to the point where it's going to get reviewed. Now, hopefully in the end, it's a futile effort, but look at what these asshats are doing. There's a reason I call them asshats all the time. You know why? Because they're asshats. Really grinds my gears, folks. September 15th, 2021 letter from Elizabeth Goody to defendants. So wait, what's the context of that? I just started reading again. I was kind of like feeling all like hot and bothered and flustered about that because it grinds my gears, folks. It just says September 15th, 2020. That didn't seem weird to me the first time I read it. It's just like a separate sentence that says September 15th, 2021 letter from Elizabeth Goody to defendants. That's what it's from, I guess. Yeah, okay, whatever. So it's not that. Anyway, and then they wrap up by stating, accordingly, defendants respectfully ask the court to order the SEC to submit these 3 additional documents for in-camera review. It's a coming, folks. I'm assuming that this is going to be favorable to Ripple. Can you imagine like a world where that would not be? Here's what attorney John Deaton had to say upon analyzing this himself. A letter just filed by Ripple attorney asking the court to review 3 additional documents in the in-camera review. One document relates to an email chain regarding discussions with a third party that received guidance from the SEC. Who could it be? Notice the SEC would not voluntarily agree to provide these 3 documents to the court for her in-camera review. I know, right? A bit suspicious, I would say. So again, to me, this seems like another bombshell. I can't see how there could be a world where this doesn't end favorably for Ripple. There's no way to know for sure, but you guys have been following this probably as closely as me, right? Can you imagine? This is like all this is good for the SEC? What the hell kind of justice would that be? I just don't see it coming. I really don't. I'll wrap up there though. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.